In recent years, a number of state courts and legislatures have recognized the legal validity of same-sex marriages. Such cases raise a number of important questions for churches and ministers that are opposed on religious grounds to same-sex marriages, including the following. Can ministers who are opposed to same-sex marriages be liable for refusing to perform them? And can a church be liable if it refuses to allow same-sex couples to use its facilities for a marriage ceremony? The highest courts in 4 states have recognized the legal validity of same-sex marriages. In each case, the court went out of its way to stress that ministers and churches are not required to perform or accommodate a same-sex marriage in violation of their religious convictions. Let me review each of these 4 cases. First, in 2003, the Massachusetts Supreme Judicial Court recognized the legal validity of same-sex marriages, but made the following statement. Let me quote. Our decision in no way limits the rights of individuals to refuse to marry persons of the same sex for religious or any other reasons. It in no way limits the personal freedom to disapprove of or to encourage others to disapprove of same-sex marriage. Our concern, rather, is whether historical, cultural, religious, or other reasons permit the state to impose limits on personal beliefs concerning whom a person should marry. In a 2008 ruling that was later overturned by Proposition 8, the California Supreme Court recognized the legal validity of same-sex marriages, but made the following observation, quote, affording same-sex couples the opportunity to obtain the designation of marriage will not impinge upon the religious freedom of any religious organization, official, or any other person. No religion will be required to change its religious policies or practices with regard to same-sex couples, and no religious officiant will be required to solemnize a marriage in contravention of his or her religious beliefs. The court cited Article 1, Section 4 of the California Constitution in support for this conclusion. This section, which was added to the California Constitution in 1974, states simply that free exercise and enjoyment of religion without discrimination or preference are guaranteed. While the court's decision validating same-sex marriage was reversed by the people of California when they adopted Proposition 8, the case still is useful because of the court's conclusion that churches and ministers cannot constitutionally be required to perform marriages that are contrary to their religious beliefs. In a 2008 ruling, the Connecticut Supreme Court recognized the legal validity of same-sex marriages, but made the following statement, quote, religious autonomy is not threatened by recognizing the right of same-sex couples to marry civilly. Religious freedom will not be jeopardized by the marriage of same-sex couples because religious organizations that oppose same-sex marriage as irreconcilable with their beliefs will not be required to perform same-sex marriages or otherwise to condone same-sex marriage or relations. Because, however, marriage is a state-sanctioned and state-regulated institution, religious objections to same-sex marriage cannot play a role in our determination of whether constitutional principles of equal protection mandate same-sex marriage. Finally, in a 2009 ruling, the Iowa Supreme Court recognized the legal validity of same-sex marriage, but made the following statement, quote, religious doctrine and views contrary to the recognition of same-sex marriages are unaffected, and people can continue to associate with the religion that best reflects their views. A religious denomination can still define marriage as a union between a man and a woman, and a marriage ceremony performed by a minister, priest, rabbi, or other person ordained or designated as a leader of the person's religious faith does not lose its meaning as a sacrament or other religious institution. The sanctity of all religious marriages celebrated in the future will have the same meaning as those celebrated in the past. The only difference is civil marriage will now take on a new meaning that reflects a more complete understanding of equal protection of the law. These 4 cases unequivocally recognize 2 fundamental principles. First, no church will be required to perform a same-sex marriage or any other marriage that violates its religious beliefs. And second, no minister will be required to perform a marriage in violation of his or her religious beliefs. In summary, every state Supreme Court that has recognized the validity of same-sex marriage has also recognized the freedom of ministers and churches not to participate in such marriages. Other courts in future cases may not reach this same conclusion. But given the current understanding of the First Amendment religion clauses, such an outcome appears very unlikely for the foreseeable future. This is especially so in those several states that have amended their constitution to define marriage as a union between a man and a woman, since state courts are powerless to alter such provisions.